Good day, ladies and gentlemen. We now come to, I guess, what could be called one of the meat and potato issues, namely the question of child support. As you may or may not know from your readings, one of the problems that we have is after a dissolution of marriage is completed, and oftentimes the children are forced to live nearly at poverty levels because of the question of insufficient child support or the enforcement of that child support. To discuss the problem of child support and the enforcement of any orders that are entered, we have two attorneys who specialize in the practice of matrimonial law in the DuPage County area, Brigid Duffield and Brigid Duffield. Welcome, both of you, to our segment.
Thank you. Thank you, Dominic.
I guess the next natural problem, Brigid, is after you have this nice order that says you're entitled to get money, how do you go about getting it? What happens if the person refuses to pay?
Dominic, that's one of the problems that we find very frequently for women today. Because women are the people that are most often paid child support, although a small percentage of men do receive child support from their spouse if they have custody of the children. What we find is that the courts have taken into consideration some ways to prevent non-payment. And recently, in the past few years, what we have found is that the courts are more willing and, in fact, by statute, do withhold automatically out of someone's paycheck.
When you say withhold automatically, what occurs?
Well, after there's been a determination as to the amount of child support that's owed, an order of withholding, which basically notifies an employer, assuming the person is employed, notifies the employer to make an automatic deduction, either payable directly to the ex-spouse or to the clerk of the court, for the amount of child support. What it does, it gives a little bit more dignity to the spouse because they don't have to go hat in hand to the ex-spouse looking for funds, and it ensures that there's going to be a payment on a regular basis. Unfortunately, what happens sometimes is that people that are not under the withholding orders may go for lengthy periods of time without making child support payments, and then the woman has to, or the spouse that needs the child support
has to... When you say lengthy periods of time, in your experience, have you seen some large what we call arrearage or back orders? Will a person become thousands of dollars in debt, or is that unusual? Or?
That is not unusual. Recently, I brought a child support petition, a rule to show cause on a petition, a rule to show cause to enforce an existing order, and the arrearage was approximately $19,000. Wow. Part of that is because women, or the person who is looking for child support, feels like if the spouse isn't going to pay, that what's the use in trying to get either the court to enforce it, or it's going to take a long time to find the person, or it's just not worth the effort because, you know, the relationship has deteriorated to the point where it's just too difficult to track down the ex-spouse for that support. But with the assistance, as Jarrett mentioned, of the legislature and the courts, what we're finding is that there are laws and statutes being enacted to help people in that position so that those people who are deserving and have been ordered for child support don't become wards of the state, and that the person who has the obligation to pay child support is fulfilling that obligation.
You mentioned that sometimes payments are made through the court. Does that create any advantages to the individual by having the payments made through the court?
I think the advantage is perception. The perception is that the person who owes that obligation has to go to the court or mail it to the court, or their employer has to keep the court notified of that payment. As a practical matter, in a withholding order, whether it's paid directly to the spouse or directly to the court, the company is responsible for making that withholding and for making that payment. So as a practical matter, the company under court order will direct that payment to wherever it's supposed to go. But I think the client, at least in my experience, my client's perception is that if he has to pay it or she has to pay it directly to the court or to the clerk's office, there's more weight to that. They feel more secure that that payment is actually going to be made. Unfortunately, what happens is that sometimes people fail to notify the clerk that they've made a job change or that they've terminated their job, and when the clerk attempts to, notify someone that there's an arrearage running, the employer comes back and says, well, he doesn't work here anymore, and that person has failed to notify the clerk's office that they don't work there anymore, or of their new employment.
The clerk's office actually keeps track of the arrearage, in other words, of what monies that's owed, and notifies the non-custodial parent that they owe money?
They can. Generally, the person who's interested in it is the custodial parent, and they can generally go and get that information so that if they decide they want to enforce that order, or if they want to try to collect it, they know exactly how much is owed. Because most often these people aren't keeping track of how much the person is in arrearage, and if they get disgusted with the fact that the person is not paying, they just kind of say, well, that's the way it is, and I'm not going to attempt to collect it.
If there's a large amount owed, do they ever actually go after, for example, the non-custodial's spouse's property rather than get an order? Do they actually take property from the individual to catch up if there's these $10,000 and $15,000?
Well, in this example that I've just given you, the person decided that he, even though he was employed, was not going to make the payment or make some kind of an arrangement to either settle the balance or alternatively to work out a payment plan on it. What ended up happening is he was found in civil contempt and he was directly thrown in jail. Now people get scared when they hear that and they say, well, my ex-husband was thrown in jail for non-payment, but the fact is that person is in civil contempt.
I see.
What happens is the person is then put on a work release program so that they can at least be making some money to try to offset some of that arrearage.
Well, it sounds like a very difficult time. I want to thank both of you. I hope that the viewers found it as informative as I did. And again, thank you for coming in, and I hope you both have a nice day.